Disclaimer. Judge Ron Rangel is providing this podcast for educational purposes only, as well as to give the public general information regarding topics related to the criminal justice system. The views, thoughts, and opinions of his guest speakers are the speaker's own and do not represent the views, thoughts, and opinions of Judge Rangel. All rise. You are now listening to Beyond the Gavel with Judge Ron Rangel, educating the public and expanding mindsets. Subscribe on our website, beyondthegavelpodcast.com, or your favorite podcast platform for more of the latest podcast episodes and updates.
Welcome to Beyond the Gavel with Judge Ron Rangel. I'm your host. First of all, thank you so much for listening in. We appreciate all the listeners. As you know, and as I've mentioned before on this podcast, I'm fortunate enough to be a guest on other podcasts. I was on one on April the 15th of this past year with a guy named Todd Marquardt. The actual podcast is named Talk Law Radio with Todd Marquardt. I invite you to listen in. We talk about the criminal justice system. Today in the studio, we have Daniel De La Garza, who's an attorney here in San Antonio. He was raised in Edinburgh, Texas, and he moved to San Antonio after high school to attend the University of Texas at San Antonio. Now, he began working at the Bexar County District Clerk's Office in 2004 when I met him, and he's also made a lot of lifelong friends and built enduring relationships at the courthouse that still last to this day. He graduated in 2011 from college, moved to Houston to attend law school at the South Texas College of Law. While in law school, Daniel clerked for the 14th Court of Appeals, served as a research assistant to a professor, interned at the Harris County Defender's Office, and worked at a criminal defense firm. Now, since his graduation, Daniel opened his law practice, where he's represented hundreds of citizens accused of crime in state and federal court. He's a member of many criminal defense lawyer organizations. Welcome, Daniel.
Thank you very much for having me, Judge. I'm really excited to be here.
Hey, we're excited to have you. Now, one thing that I didn't mention was your personal accomplishments. One thing that you wanted me to know is that you are a proud father and husband.
That's probably one of my proudest accomplishments.
Congratulations on that. Is your wife also a lawyer?
She is. She practices personal injury mostly, but I've gotten her to come in and start taking a little bit of appointments to help, kind of get that caseload down in the misdemeanor court. So she's venturing into the criminal defense world. Very excited for her.
You have two daughters, is that right?
I do. Brooklyn and Kennedy. Brooklyn's 7, and then Kennedy is 1.5, and she's a lot, but she's a lot of fun too. So.
Well, congratulations, Danny. You know, I always enjoy seeing you in the courthouse. We've been almost co-workers for a very long time. You were in the district clerk's office when I first got elected as a judge. And I think you were coming in quite often to talk to us and hang out with those in the courtroom.
That is definitely true. I remember you, Judge, as a practicing attorney. And I remember you running for office, you being successful at it. I remember talking to you about the way you ran your campaign. It was very impressive. One thing that I never, ever forget, when I go to Spurs games, I remember you telling me that you were out there at like basically every single Spurs game during the election, handing out cards, shaking hands, meeting people. And I've always thought that that's very, very impressive. We have been colleagues. I worked right down the hall from your court, and I'd come in, and maybe a little too much according to the supervisor, but I'd come in and we'd chat and all that stuff. So
I don't think so. In fact, I know that you recommended the book that I subsequently started using in my political science classes at UTSA.
I did, and I love that book. It's called What is Justice? And it just has a bunch of different theories of punishment, of the justice system, of complaining witnesses, victims, defendants, a bunch of different ways to look at it. Yeah, that's a very good book.
Which is a great segue into today's topic. Today, we're talking about the death penalty. That's an interesting topic. Now, you were one of the lawyers on the Otis McCain jury trial, which we had in this court.
I was.
Otis subsequently got the death penalty from the jury, and that case is making its way through the appellate courts. We can't talk about anything related to that case other than what is on the record. But what was that experience like for you?
Well, you know, it was a very, very, very good experience as far as learning the different ways to try a death penalty case. It was a very good experience working with the first and second chair, who I've known for a very long time and worked under for many years. It was a very good experience learning how to do the voir dire, which is very, very complicated. And it's a totally different way to conduct one than what we normally do.
Mm-hmm.
And then, of course, it was a high pressure case. We were live streamed the entire time.
Mm-hmm.
It was a very, very long case. So there was multiple lessons to be learned as far as the depth of the evidence, all the, the voir dire and the different way to do that. And then, of course, just the high pressure situation that we were in every day for, what was it, Judge? A month and a half?
It was a long time. Yeah. And it took us at least 6 months to pick that jury because of COVID.
And that was quite an experience within itself.
And as you mentioned, the Otis McCain trial was the very first live stream jury trial in Bexar County. And it's the last time in Bexar County that the death penalty has been assessed by a jury. So it is an interesting case study in and of itself. Well, let's talk a little bit about the death penalty. I have some statistics here. In the United States, 23 other states have abolished the death penalty. Currently, there's about 2,500 inmates that are serving under a death sentence. The number of inmates pending under a death sentence has consistently decreased since about 2000. Texas leads the nation in the number of executions since the death penalty was reinstated in 1976. Now, death penalty cases are a little different. One of the things that people always come to me is, why wasn't this person sentenced to death? Or why wasn't this other person looking at the death sentence? And I'll give you a couple of examples. We had a jury trial where a couple of individuals killed another person who was going to sell some drugs, chopped up the body in a lot of pieces. Before they did that, they tortured him. They made his girlfriend watch. They tortured his girlfriend. They burned the body parts in the backyard in a barbecue pit. People were wondering why this individual or why these defendants could not be subject to the death penalty. There are other situations where you have serial sexual assaulters of children who are not looking at the death penalty. And the reason for that is because the statute is very specific.
Yes.
First, you have to have a murder.
Yes.
So how do you define a murder in order to get to capital murder or a potential death penalty sentence?
So a murder would be the intentional killing of another human being, and that's just a basic law school definition. Capital murder would be, and the best way to describe it would be murder plus something else. And in Texas, we have, I believe it's 10 different manners and means of the plus. So multiple killings. A classic example would be a guy who goes in and is going to hold up a convenience store and then unfortunately kills the clerk. That would be the classic example.
So that kind of situation would be somebody is committing a felony offense and then kills somebody as a result of that.
And the felony offense is what we used to call the 3G offenses, which are the violent crimes: kidnapping, sexual assault, the aggravated robbery, stuff like that. So yeah, that would definitely get you there.
The indictment in the Otis McCain case was the killing of an officer during the course of his duty as a peace officer. You could have an individual who employs somebody else or kills somebody else for what we call remuneration or for profit.
Pretty common one in Bexar County, unfortunately, would be the murder of a child under 10 years old.
That's right.
Although notably, the law says up to 14-year-old, but 10 to 14, you just wouldn't, it's capital punishment, but not death penalty eligible.
And that used to be under 6.
Yep. It used to be under 6.
So in order to be subject to the death penalty, then you have to have an intentional murder. Somebody has to intentionally kill somebody.
Yes.
And then you got to have one of these other aggravated circumstances on top of that.
That's correct.
And as it relates to death penalty cases, if somebody is charged and found guilty of capital murder, then there are only 2 potential sentences.
Yes. The 2 potential sentences are life in prison without the possibility of parole.
Mm-hmm.
Second possible punishment would be death.
Do you happen to know when that changed? Because I remember when I first started practicing as a lawyer, as a prosecutor, the sentences would be life in prison or the death penalty. Life in prison was subsequently changed into being life in prison without the possibility of parole. And since that time, the actual death sentences has decreased.
I don't think I was a lawyer at that time, but I'm kind of nerdy and I worked here. So I like keeping it. I think it was, and again, I'm not certain, but I think it was in like the 08 to 010. So by the time I started practicing, life without parole as a punishment was certainly possible. Now, you mentioned, Judge, the fact that the amount of people charged, or not charged, but that are assessed the death penalty has decreased. And I think there's 2 possible reasons for that.
Uh-huh.
First of all, as a general proposition in Bexar County, the death penalty these days, it's certainly not nearly as active as it was during the administration before the DA now, but the prior administration. During that time, it was during the Susan Reed administration, Bexar County was incredibly active in assessing and pursuing the death penalty.
Society was in general, though, right? Aren't prosecutors across the state more active in pursuing the death penalty?
Absolutely. I would say absolutely. I don't know if as a society, our tolerance for it has decreased. I can tell you the crime certainly hasn't, but I don't know if it's that our appetite for it has not decreased. But the other thing going through my mind is I've read case law and I've talked to many, many people about the fact that the death penalty should be reserved for the worst of the worst. So the worst of the worst can't be everybody, and it can't be everybody charged with capital murder.
Right.
So if we truly are assessing it and sentencing people to death that are supposed to be the worst of the worst, I would think that the logic that would follow would be that, yeah, it certainly would decrease how active we are in assessing it.
Well, there are some theories that state that juries would be more afraid of not assessing somebody the death penalty back pre-life in prison without parole, because parole means if somebody was sentenced to life, after 30 years or at some point, they'll be eligible for parole. And so then the question would be, are you comfortable with this person ever getting out of prison if they didn't get the death penalty? So now, without the possibility of parole, that seems to have changed how folks look at the potential future dangerousness of an individual that was sentenced under a death penalty case.
I think that's a very, very good point. And I think that is also probably a big reason too why we've decreased it.
Well, kind of staying on that topic, there's always that Eighth Amendment argument, right? The cruel and unusual punishment idea that's always been out there. And I know that's always being tried by criminal defense attorneys.
Yeah, that's a very common ground to raise on the appeals. And now, as far as the Eighth Amendment argument goes, I think these days there's a viable argument to be made because the petrobarbital, I believe it is, which is one of the drugs,
right,
is in short supply. And my understanding is that the inmate, when they're being executed, is able to feel, and I've read it being described as fire going through your veins, and after drowning is how they feel, and they're just gasping for air and dying. So the idea would be that the method of execution is cruel and unusual, and it would be in violation of the Eighth Amendment's prohibition of cruel and unusual punishment.
Yeah, and just so folks know what that means. So the Eighth Amendment specifically states excessive bail should not be required, nor cruel and unusual punishment inflicted. And so back when the framers of the Constitution, 1787, wrote the Constitution, at that time, the death penalty was looked at very differently than it is today. Cruel and unusual punishment in 1787 may not be the same thing as it means in 2023.
I think we had drawn and quartered people during that time, and I know hanging was pretty was common. So absolutely.
Death by firing squad.
I think that's still a legal method of execution these days.
That's right. That's right. So as we stated, you are now on the first chair list in order to be able to take death penalty court appointments.
Pursuing it, but I don't think I've been approved yet.
So you obviously understand what it takes to be an appointed counsel for a capital murder case.
It's a lot.
And so the first thing is obviously you got to be a member of the State Bar of Texas.
That's a big one.
You have to exhibit proficiency and commitment to providing quality representation to defendants who are looking at the death penalty. You cannot have been found by a federal or state court to have rendered ineffective assistance to counsel. Got to have at least 5 years of trial experience, criminal law experience. Here's the other issue. You must have trial experience in 1, the use of and challenges to mental health and forensic expert witnesses, and 2, investigating and presenting mitigating evidence at the penalty phase of a death penalty trial. How difficult is that? And we've talked to folks in the legislature about how challenging it is to qualify first chair court appointed lawyers in capital murder cases because of that last one.
It's extremely difficult.
What is it that makes that so tough to find?
Well, these days, getting a death penalty trial is almost impossible to have.
A death penalty trial where the state is seeking death.
And somebody presents mitigation. And that's a statute. Right? It's actual law is what we're reading here.
It's 26052.
But yes, so that's codified. It's law. It has to be followed. There's no, well, the judge knows that this guy can do it or this lady can do it, I'm going to put him on. There's none of that. So it's really difficult. And if you think about that statute, you have to lose your trial. and then go and present the mitigation. So during the O'Kane trial, my task during punishment was to present, we called her the map lady, but it's basically demographics of the city, of where, Mr. Otis grew up, and the kind of life he lived as a child, and who his mother was, and what kind of, just the demographics of the area. And the idea would be that the jury would say, well, if he grew up in this part of town and that's not the greatest part of town, it was tough for him. And, maybe we give him a little bit of a break and that kind of stuff. So the idea would be that his upbringing was mitigating, and that's what we presented. But me being able to do that at least got me on the path to qualify to take first chair appointments.
So mitigating evidence can be anything.
It can be.
Right. It could be anything that would give some sort of a reason for people on the jury to say, maybe we should not sentence this individual to death.
Correct. And that is a huge part of the analysis. And there's two special issues that the state must prove and that the defense, for lack of a better term, tries to disprove during the punishment. And it's the future danger of the defendant. And then if the defendant is found to be a future danger, then is there anything mitigating about him? And mitigating evidence, in my opinion, it's either positive mitigation or negative mitigation.
Right.
And I think that the positive stuff would be like, he grew up playing the piano, and he's a brilliant cellist and violinist, and he can write symphonies. The fact that he's somebody's child, that he's a human being or she's a human being, that the person, can breathe, can be mitigating. Almost anything can be mitigating. On the other side, I think of the negative mitigation, which is like, well, the person was abused physically or emotionally, sexually as a child. The person was, lived in a trash can, was thrown in a trash can baby.
Mm-hmm. Yeah, we had that trial.
We did, and I recall that.
Yeah.
I mean, there's all kinds of things. I think, mitigating evidence can be anything, can be a lot of things.
What kind of person is he? Why is he that kind of a person? Right? Those kinds of things.
In a punishment trial, no matter if it's death penalty or a misdemeanor or municipal, it doesn't matter. Why is the question during punishment? Because in trial, we've talked about who, what, where, when is what. That's the indictment.
Right.
But the why I think is where, as a defense lawyer, because we represent people who do some people who do bad things, right? You're not going to get anywhere with a judge or with a jury by denying it. So if you kind of own it and then accept responsibility for it and kind of go from there, that first of all buys you credibility in front of people, but it also mitigates the punishment.
And by looking at it, it's difficult to be able to get appointed as a first chair indigent defense capital murder defendant or defense counsel because there are so many fewer capital murder trials that are going on today. So you mentioned earlier, prosecutors are seeking the death penalty much less now for a lot of reasons, but understanding that, it makes it more difficult for people to have that kind of experience.
From the practitioner's standpoint, if somebody wants to qualify and get into that kind of work, it's incredibly difficult. I would just say I lucked out. I had a good mentor, and I worked with him since I started practicing. And at some point in time, he was like, you need to come on and help us with this case. And that's how I got involved in it.
Yes. A thing that makes it difficult to get qualified to do these cases, because there are fewer and fewer more trials going on, there's fewer opportunities to get experience. So we're running out of people to appoint capital murder cases too. One of the problems that we have, as judges, have discussed is that because there are so few lawyers that handle first chair capital cases, a lot of these lawyers have to take more than what best practices would dictate. In other words, more cases than what maybe they should, but the state is forcing attorneys to do that by not allowing other attorneys get qualified to do capital cases. What kind of pressures and demands does that put on somebody like you that wants to be involved with capital murder?
First of all, the amount of preparation and the amount of, and we're talking about a death capital case that's involved, is, and the amount of time commitment to it is an incredible obligation to take on. And some lawyers I know have multiple cases that they're first chairs on. So I think that at this point in time, I believe there's less than 10 qualified lawyers from our fourth judicial region,
which is about 30 something counties.
That's a lot of, potential for a lot of capital murders. And so at that rate with less than 10, I would submit that it would be almost impossible and maybe borderline malpractice to divide these up by 10. So I'm not sure what the solution is, but yes, it is incredibly difficult to qualify, first of all. And then the amount of capital murders that happen just in Bexar County alone, it's a high number.
One of the bills that I pushed on behalf of the judiciary is the concept that other types of cases other than capital murder cases can help an attorney qualify if they have enough of mitigation experience. So let's say somebody was a trial lawyer that tried a lot of murder cases or tried a lot of sex cases. And as a result of that, they've had plenty of experience with mitigation evidence. So something like that, maybe to substitute this particular statute, this particular provision in the statute, might help.
Yeah, I think that's actually a great idea. I would suggest that the big difference between a capital murder and a murder is the depth of the evidence, first of all, and then, of course, the punishment and voir dire. But the mitigation that's presented in the punishment phase of a murder, it's virtually identical.
Another issue, which is pretty common, is that these kind of cases don't always come in with one defendant, right? Because of the law of parties. Do you have an idea as how something like that could work?
Absolutely. Yeah. And it's tough when that happens too. I was on a case once, capital murder of a 10-year-old or under child. Mm-hmm. And there was about 5 or 6 co-defendants on there.
Right.
And then each defendant has 2 lawyers. So you're talking a minimum of 10. I think ours had 3 because I was appointed the second chair. And then we got another lawyer who signed on, hired but pro bono, because he wanted to get this was a death case. Right. He wanted to get some qualification. So then what you have to do is parse out, okay, who's on my side, who's aligned with me, who's not aligned with me. That's more of the the strategy part of it. But from the viewpoint of the judiciary, it's where are they going to find 10 lawyers that are on that list to represent these difficult men and women.
And so for folks that don't understand, what that basically means is anytime there's a scheme, and I'll give an example. We had a capital case not too long ago in the 379th where 4 young men, they were all 18, 19, 20 years old, devised a plan to buy some drugs and to rob or steal with a gun from the individual that was doing the drug dealing. So 4 of them were involved. One of the guy pulls out a gun, shoots and kills the drug dealer. So now you got 4 separate defendants. Law of parties means if any one of those individuals was involved in the felony offense, acting in the course of committing the offense, scheming, planning, all the other things that would make them just as culpable in their mind to wanting to rob this person, to commit an aggravated robbery, and then a death resulted, all 4 of them are looking at a capital case. So all 4 of them could get, by law, the death penalty.
That's correct.
And so those kind of cases happen very commonly. So there's a lot of times where I come into the office, Trish, my coordinator, says, we just got a capital case and there's 4 co-defendants. That means we got to go out and find 4 first chair death certified defense attorneys to represent every one of those individuals. Because it takes so long for somebody to get death penalty eligible as a defense attorney, then the age of the attorneys is going up. So the attorneys are looking older than what they used to because it's harder for young attorneys like yourself to be able to handle those kind of cases by statute.
It is. And I think that to a certain extent, the statute has it right. I think that in order to be on these cases, you should have significant amount of experience. So, I think it's like that for a reason, but the spot that it puts, the courts in, I think is difficult.
What kind of pre-trial stuff are you looking to do before you actually begin the jury trial?
There's a lot to do. So you should have that team in place, a mitigation specialist, any kind of forensic experts that you're going to have, your investigator, your second chair, and then just depending upon what kind of case it is, there'll probably be residual experts, fingerprint guys. We've had GPS guys that we've had to use, cell phone experts. There's just
any expert you can imagine.
You name it, it could possibly come up. So ideally, if you're doing it right, you should have been working on this way back pre-indictment, those 8 to 12 months prior. We've probably gone through many, many settings to gear up for trial, but pre-trial, you're going to want to have all of your issues identified through pre-trial motions. So if you're going to try to suppress evidence, you want to have those motions on file. You want to know who their experts are. You're going to want to know what they're bringing in as far as 404B, which can be its whole other topic of one of these podcasts.
And 404B is that's extraneous evidence that is unrelated necessarily to the acts in this case, but that could be used against the defendants as some sort of character issues.
Yes, Your Honor. To prove like motive, opportunity, identity,
Right.
intent, stuff like that. And those can be devastating.
All right, let's go ahead and do a quick Q&A break. We'll be right back.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Now, folks have asked me about our Q&As. These are not questions that are prepared ahead of time. These are straight from you, the listener, and they're provided to us at the time that we're doing this podcast. So, question is, how can you expect a witness to testify about an event that happened years ago?
So from the defense lawyer perspective, I would say that they're not able to. They can't remember things. And I sometimes can't remember what I did yesterday. A lot of times a witness is not expecting to they're not like, okay, the crime's about to happen, let me wait for it. So a lot of times they're not really prepared for what they're going to see. So there's a lot of good, fodder for cross-examination on testing somebody's memory. And is this exactly what they say? Okay, well, let me ask you, sir, when's the last time the prosecutor showed you this report? It was this morning, wasn't it? Yeah. Okay. Well, thank you. That kind of stuff is the line that.
So do you think it's an advantage for the defense for time to pass by before a person comes in to testify as it relates specifically to that person's testimony?
Absolutely. Yes. I learned very early on from a lawyer that I've done a lot of work with over the years.
Mm-hmm.
Time and distance is our friend in these cases. He's like, put as much time and distance as you can between the offense date and your trial date, and you'll get good results. And that's still true.
And sometimes it's difficult for folks that are charged with crimes, because I remember back when I was practicing as a defense attorney, clients would be asking me, why is my case taking so long to get processed? And I would explain to them, look, we have to be the next person on that trial docket that is ready for trial, that's the oldest case.
Yeah.
And so sometimes it takes a while to get to that particular point. But I would tell them, I understand you're having sleepless nights. I understand you're going through stress. I understand you have this fear of not knowing what's going to happen to you. But in the long run, we're handling the case as best as we can, and time is really your friend.
Yeah. Yeah.
That was a good question.
I like it.
Thank you so much for that question. Keep on asking questions. We love getting the questions from you. They always challenge us.
This is Q&A with Judge Ron Rangel. Submit your question today at beyondthegavelpodcast.com.
Welcome back. I'm here talking to Daniel De La Garza. So let's say the day has come. You're getting ready to pick the jury. Jury selection in capital cases is very different than other types of cases.
Yeah.
What does it look like in a capital case from the defense side?
It's a long process. There are a lot of people. And the most significant difference is this is all done individually, as opposed to, 175 people in a room, and I get to the state questions them, and then I get to question them, and then we pick after that. So just depending upon, your own personal style. I'm talking about the defense or the prosecutors. I like it. I like the individual stuff. First of all, in a jury trial, you got 75 to 100 people or 200, whatever it is. Man, I'm one of these guys that is super anxious about, okay, are they going to be talking to each other? Are they going to hear something that the other person says and then influences this side? Am I going to bring something out that just totally like to try to challenge this one for cause? Am I going to say something that now taints the entire panel, but I got to get that person out? So my natural disposition makes me kind of like an anxious person where I want to make sure that everything's in line and perfect and stuff. So, the normal voir dires where there's a bunch of people, that can be pretty nerve-wracking for those reasons, right? So what I found was cool was that when you're questioning people, there are none of those considerations.
So in every other case other than a capital murder case, jury selections, generally speaking, take a day. So you have the judge speaks for a while. Usually I speak for about 40, 45 minutes. The state speaks then for a while, let's say an hour, hour and a half, depending on how long the judge gives them. And then the defense speaks. Then strikes are exercised.
That's correct.
One day. In a capital murder case where the state seeks death, the judge gives a presentation, figures out then who's qualified to be on that jury. If you're not qualified, then you need to let us know now. Mm-hmm. Find out what potential jurors need exemptions or want to get off that jury because they qualify for an exemption. Then we'll take the next 150 people and we'll bring them in maybe 4 to 6 people per day, depending on how many people we get to interview that day, interview them individually. In doing so, we got to be able to ensure that they can follow the law. Following the law means that they can consider the full range of punishment. So if somebody comes in and says during your individual voir dire or your individual examination of these potential jurors, if somebody says, I can never give somebody the death penalty, then they're automatically excluded from being considered from being on that jury.
So let's just say that that's the hypothetical that we get. I could never give somebody the death penalty. Then the counterintuitive, so that's what I'm talking about. It's counterintuitive, because then you got to come in and say, well, because I want that person. And I can tell you're a person that will follow the law, right? So the law says you have to at least be able to consider it. And, you just go through this whole thing. And then at the end, you ask the question, okay, so based upon all the stuff we just talked about, do you think you'd be able to listen to everything, listen to the judge, to the prosecutors, to the evidence, and you want them to say yes, which is, again, counterintuitive, because you want them to say no. You don't want them to give your guy the death penalty, but then you want her on the jury or that person on the jury.
Now, an interesting anomaly with the death penalty, and it's basically a result of U.S. Supreme Court decisions, is that in Texas, a 17-year-old is considered to be an adult for criminal type cases and statutes and being charged in a criminal court. But to get the death penalty, somebody has to be 18 years of age to be assessed.
Correct. There's Atkins, Roper, and Simmons, right? And I get confused as to which one is the mental disability and which one is the 18 or whatever. But it's one of those cases that came out, I want to say 2010, right around there, that said that it's unconstitutional. It's cruel and unusual. Back to that 8th Amendment we talked about earlier, that it would be cruel and unusual punishment to assess the death penalty on somebody less than 18 years. So no juvenile executions are allowed. And I think that goes back to the whole, the prefrontal cortex and the bad decisions that young men and women make because their brains aren't fully developed and stuff like that. So I think it kind of harkens back to that.
So going back to that first phase of trial, somebody is found guilty. Automatically then, at that stage, the person's going to get life in prison without parole until you get to the second phase. So there are a lot of trials where the state is seeking a capital murder conviction, but not death. So in those kind of cases, once the guilty verdict comes in by a jury, if that guilty verdict comes in, then that trial is over and the judge sentences that person to life in prison without parole.
Correct. However, and I never got caught like this. I just knew intuitively, just logically, you've got to still be ready, man, because there could be a lesser included, right, on that stuff. And you've got to be ready with some kind of punishment evidence. If not, I can see situations where somebody's, I don't know, in the hallway scrambling for mother or father or somebody to come in. And that's just not the way to do these cases.
That's a good point. And so when you say lesser included, you mean a jury comes back and says, we're going to find you not guilty of a death penalty eligible. We're going to find you guilty instead on the lesser included offense of a murder charge or an aggravated assault.
Correct.
Something that has an element or more less than what a capital case is.
So the state's seeking the death penalty and you're not subject to the life and without parole and you're not just going to be stand up and sentenced, then we got to go into the punishment phase. And it's kind of clunky, and I'll explain why I think it's clunky, but it's that, can the state prove beyond a reasonable doubt that there is a reasonable probability that the defendant will commit future acts of violence that constitute a continuing threat to society? That's the first issue.
And so what you're saying then is the jury never actually deliberates and comes back with a verdict of death.
That is absolutely correct. And I think that the point that we should make, and that what I think our listeners should know, is that was done, like you said, as a result of a Supreme Court decision, I think in the mid 70s. And I believe it was a case called Furman, where the death penalty was being disproportionately assessed against minority defendants. And I think that to remove a lot of the arbitrariness where they were saying, okay, I don't like the way this person looks, death. And there would literally be, 2 lines, life or death.
Right.
Bad. That's really bad. Unconstitutional for many, many reasons. Due process stuff, maybe the cruel and unusual stuff, lots of reasons.
That was Furman. Was that in 1972? Is that what halted the death penalty executions in California?
I believe even Charles Manson got off of death row at that point.
Yeah.
I think it halted it for a few years, and then the scheme started to be rewritten. And in Texas, what we ended up with was the scheme, or a very, very similar version to what we have today.
All right. So you talked about the Furman case. That was a Georgia case in 1972, where the words cruel and unusual punishment of the 8th Amendment was actually interpreted by the court. And they ruled that the way the death penalty at that time in 1972 was currently administered was unconstitutional, but the U.S. Supreme Court found that the death penalty itself was constitutional.
That's a great point. It was being applied arbitrarily and capriciously, I believe was the language. But yes, the actual imposition of the death penalty is constitutional.
And so what happened after that, states like Texas then revised their statutes in order to make the death penalty process constitutional according to that case.
Absolutely.
And then this question is always asked to me: is it more expensive for a jury to put somebody to death or to assess life in prison without parole?
I haven't seen the statistics. I would think it's probably more expensive to house somebody throughout their natural life.
So let's say a jury comes back, they answer yes to the first special issue, no to the second special issue, that there is no mitigating circumstance where a juror would want to spare this individual's life. Now they've been assessed the death penalty by the court. What happens then? What does the appellate process look like for somebody who's been sentenced to death?
I've come to learn of it as the Texas highway or fast track to the death penalty. And the reason why I've heard of it described like that is because generally, and murder is just the easiest example to go back. So I just keep going back to that. In a murder case, you're found guilty, you're assessed a life punishment or 50 years or whatever, 40 years, whatever it is. So the appellate process would be a motion for new trial if you're going to do that. And you can bring in extraneous, stuff from outside the record. You can say it's not a good idea to do it, but you can say the lawyer did a bad job at that point. You can say the prosecutor committed misconduct. So there's different topics you can raise in the motion for new trial. That's the first procedure. And we're talking about normal cases. In a non-capital case, that process takes about, I would say, 4 to 6 months maybe for the briefs to be filed by both sides, and then 8 to 12 months for the fourth court or whatever appellate court you're in to hear the case and to decide it.
So let's kind of spell that out. After you have a trial court, listen to a case, judgment is assessed, then there's a 30-day period where a defense or the state could file a notice of appeal and a motion for new trial. That begins a direct appeal process.
Correct.
The writ process is something different. Capital murder cases in Texas are the only types of cases where an individual can file a direct appeal and they can file a writ simultaneously.
Absolutely correct.
Do you want to explain what that means?
And that is what I'm talking about when I say the fast track, because what you're doing is you're getting basically both procedures done at the same exact time.
And it goes straight to the Court of Criminal Appeals.
Straight up to the Court of Criminal Appeals.
Which is, for folks that don't know, that is the Supreme Court in Texas for all criminal cases.
That's correct.
So you actually bypass the appellate court or the intermediate appellate court.
They get skipped right over and they go straight to the highest court.
What's it like to represent somebody who could potentially get death as a result of the trial that you're representing them in?
It's lots of sleepless nights, and it's a lot of getting up and okay, oh, I remember this. Let me go and I will pull up on my phone. I'll get my Dropbox and I'll go to the Discovery and it's a big responsibility.
Your mind never stops working.
No,
you're always focused on it.
But I like this stuff. So when I'm not working, when I'm watching TV, I'm work. But to me, it's not really work, But yeah, it's a big burden as far as the gravity of the situation. I mean, somebody could be given the death penalty. I mean, I just think it's a thing where it's a big responsibility, a lot of work that needs to be done for somebody. They deserve, quality and good representation, somebody who's facing the death penalty. And as far as what other people think, how can you represent this guy? Because I've gotten that even from prosecutors. How can you represent this guy? How can you do this? And the retort is always this: it's, if I was a doctor, because I compare a lot of stuff we do to doctors, right? If I was a doctor, right, the doctor doesn't say, oh, okay, I got a guy in for surgery, he needs a heart transplant. The doctor say, okay, hold on, this guy a rapist? Is he a murderer? Or is he a good guy? Does he, what does he do for? They don't say that. They just work on somebody. And that's how I approach it. I approach it like a doctor. So I somebody's charged with a crime, they have the right to a lawyer, they have the right to a high quality, in my opinion, representation. And I am willing and able to provide that to them.
It's no secret that lawyers have a high rate of depression, have a high rate of suicide. What are some of the kinds of things that you do as you go throughout the course of your life to ensure that you stay mentally healthy, physically fit, those kinds of things?
Yeah, that's a great question. I've been around these courts for a long time in one capacity or another, and I've seen all kinds of bad stuff happen to people. So when I came back from law school and I was going to start and venture into this stuff, that was a big concern and a big consideration. It's like, I've got to make sure that because just by my general nature, I'm a pretty like happy-go-lucky, like really
I agree.
kind of chill guy, so this high stress stuff is not really my cup of tea. But the way that I've learned to deal with it is just, I take time for myself. So Friday nights, my kids and my wife knows that's beer drinking time, that's watching TV stuff, catching up on the games, nerdy stuff that I like to do. Like, you're gonna think this is so weird, like read case law. That's what I like to do. I like reading sci-fi books a lot, so I take time for myself. I spend a lot of time with my family. My wife and I like to go to Costco, which is kind of weird, but that's just what we like to do. I make sure that I'm up at 6:30 every morning, that I get my kid ready for school. I walk her to the bus stop, or my wife will take her to the bus stop. To the extent that I can, I'll try to be back home by 3:30 to pick her up or go back to the bus stop, eat dinner or whatever. By like 7:30, 8, the kids are asleep, and I'm back on my lazy boy where I spend a lot of time, and I'm reading. I'm on my phone answering questions, calling people back, texting people back, talking to new clients, downloading Discovery. I'm doing all. So that's kind of what a typical day, is. In the mornings, I spend a lot of time in court, but I like that stuff, So to me, it's kind of not. It's like that thing, It's like, what is it? It's do something you love, you'll never work a day in your life. That's
Art
kind of
Linkletter.
Yeah. That's kind of where I fall in.
There's a lot of studies that have shown that this is the age where, you're going through life, you got the young kids, you're married, you're sharing your life with people. This is a time of your life that people always look back and cherish. It's a valuable time of your life to appreciate everything that's going on. And we really are blessed to be in this profession.
I love it. I love it. I mean, from the inside looking out, so to speak, I mean, it's a lot, it's a lot dealing with a family, and then the work stuff is a lot, a big, and I think you and Judge Guerrero hit on this a little bit, but, we're not just lawyers, we're also businessmen. I run a practice. I have an assistant that oh my God, I rely on her. We have been through a lot together. We used to work here together, and then she came and worked for me, and she's been there for, I want to say 6 or 7 years now, but without her, and so she's a very, very big part of this. Without her, Janie is her name, I don't think I'd be able to do half of this stuff.
I feel the same way about Trish, who's a court coordinator that's been working with me for 23 years or so. It's tough sometimes to work in the profession where people don't always understand what happens in the court system. And because of the internet and because of what they see maybe in the media, there's always some perception that there's something wrong going on. There's always some perception that things aren't always as they appear. What kind of thoughts do you have as it relates to that?
Yeah, I get what you're saying. I don't see it. And if there was something bad going on here and it relates to our clients, our job is to call it out. There's different ways to do that. There's ways to be respectful and still, make your point. But I think that, we'd have a duty to call stuff like that out. I've been around these courts a long time. I don't see anything weird like that. But yeah, I do understand what you're talking about. And I've seen all that stuff. I've seen lots of comments about the lenient sentences and stuff like that given by the DA's office. I'm not going to say that hasn't ever been my experience, but generally they're tough, especially on violent crimes. So I would think that the perception in the media versus what really happens here, it's too different. It's night and day.
When you're talking about the DA's office, what I hear you saying is they got to take everything into consideration. And based on that, they have to make certain decisions.
Yes.
Well, Danny, I've enjoyed talking to you.
I have too. This is great.
Are there any last words that you'd like to part with?
Thank you for having me on. I am always happy to be in your court, and this was a great experience. Thank you.
Danny, it's always a pleasure having you in the court. You've reached the end of this episode. Thank you so much for listening. We'll be back in 2 weeks.
You've been listening to Beyond the Gavel with Judge Ron Rangel. Join us in the next 2 weeks where we are educating the public and expanding mindsets. Head to our website, beyondthegavelpodcast.com, or your favorite podcast platform to subscribe to the latest episodes and updates.